Welcome to the Entertainment Law Year in Review, the cases that rocked the entertainment world in 2025. I'm Keith Kelly, chair of the Beverly Hills Bar Association's Entertainment Law section. The Entertainment Law section is sponsored by Lawyers Mutual Insurance Company. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that Lawyers Mutual is directed by a group of dedicated lawyers. They offer special rates with competitive premiums for a wide range of areas of practice, including entertainment law. Learn more at lawyersmutual.com. I'm delighted to introduce our speakers, Christine LaPera, Aaron Moss, Peter Anderson, and moderator Pierre Pine. Christine LaPera is a partner at Mitchell, Silberberg, and Knupp and chair of the firm's music litigation practice group, representing leading entertainers and media companies in high-stakes copyright, trademark, contract, and right of publicity disputes. A nationally recognized trial lawyer and strategic advisor, she has been repeatedly honored as one of the industry's top music and entertainment litigators. Thank you for joining us.
Thank you very much. Very kind.
Peter Anderson is a partner at Davis Wright Tremaine with more than 40 years of experience in copyright and entertainment litigation. He represents leading artists, record labels, and media companies in high-stakes intellectual property disputes, including landmark cases before the U.S. Supreme Court and federal appellate courts. Thank you, Peter.
Thank you.
Aaron Moss is partner at Mitchell, Silberberg, and Knupp, where he represents leading media and entertainment technology clients in high-stakes copyright, trademark, First Amendment, and complex intellectual property disputes. A nationally recognized authority on copyright law, he also publishes the widely read blog Copyright Lately and is frequently cited by courts, scholars, and major news organizations. Thank you.
Hi.
Pierre Pine, finally, is a partner at McPherson LLP with more than 2 decades of experience handling complex entertainment and intellectual property litigation. Since beginning his career in 2001, he represents clients in high-stakes copyright, trademark, contract, and business disputes in both state and federal courts. Now let's get started. Over to you, Pierre.
Great. Thanks, Keith. Appreciate it. Thank you, guys. Welcome to everybody who's tuning in for this program. Happy to have you here. Just before we get started, excuse me, I just wanted to thank Loeb and Loeb for their continued allowing us to use their case summaries for our program materials. And I also want to, as part of our program materials, and I also want to thank Emma Astrop, who has been a great help to us in helping to organize and put together those case materials. Those of you who've looked at the materials know that there's a lot of cases. Obviously, we're not going to cover everything there, but it's great for people to have as a reference point for all the important cases that have come down in the last year. We've got a lot to cover, so why don't we get started? Aaron, I know we've got some copyright AI cases that everybody wants to hear about.
Great. Thank you for having me. So obviously a lot to cover. And I think notwithstanding that we're only a few weeks into the new year, there's already enough for a 2026 year in review. And we're going to cheat a little bit. Christine and Peter are going to slip in a couple of the new cases. But I'll go through just a few of the key AI cases that were decided last year. Most of them are still ongoing. We got 3 federal court rulings on fair use in the training context. There's 1 historic settlement, and then a couple cases that remind us that not every legal issue involving AI is a copyright issue. So the first case is on training. And actually on this issue, the courts are split on whether training AI on copyrighted works is fair use, and how you got the works matters, maybe, depending upon which judge you have. So let me start with Thomson Reuters versus Ross Intelligence. This is the first case where a court rejected a fair use defense in the context of AI training. Ross built a legal research tool to compete with Westlaw. It used Westlaw's head notes to train the system. And the procedural history of this one is kind of wild. So back in 2023, Judge Bibas denied summary judgment, set the case for trial, and literally just a couple days before trial was set to begin in August of 2024, he withdrew his opinion. Last February, he came back with a new ruling, this time granting summary judgment for the plaintiff. And there were two issues. The first one was whether Westlaw headnotes are even copyrightable in the first place, including headnotes that were just verbatim quotes from judicial opinions, which of course themselves aren't protectable. He said yes, and his reasoning was that the editorial expression in selecting which words to quote cleared the originality threshold. And so he compared headnote writers to sculptors who choose what to cut away, what to leave in place. The analogy is questionable. I think that there's a fundamental difference between sculptors that have, virtually unlimited expressive choices and headnote writers whose job it is to faithfully convey what a court held as opposed to being creative. So it'll be interesting to see whether that aspect of the case holds up on appeal. It is up now at the Third Circuit via an interlocutory appeal. On the fair use issue, which is the one that most people are focused on, the court ruled for Thomson Reuters, found that Ross's use was commercial, non-transformative, and aimed at building a direct competitor. The caveat here is that, as Judge Bibas emphasized, this is not generative AI. So the Ross tool does not create new content. It essentially just retrieves existing judicial opinions. Court said generative AI may be different. So bottom line is that Thomson Reuters, it's an important case, but it may not travel well. And as I said, it's up on appeal to the Third Circuit. Getting to generative AI, we have Bartz versus Anthropic, where Judge Alsup found that Anthropic's training on lawfully purchased books was quintessentially transformative. But where Anthropic ran into trouble was downloading over 7 million books from shadow libraries and keeping them in a centralized repository. So that, the judge found, was a separate act of infringement, found that maintaining a library of pirated books was not fair use. And so that distinction between the training and how you got the training is what really created the massive exposure in that case. There were statutory damages theoretically of up to $150,000 per work, with exposure potentially in the tens of billions of dollars. And Anthropic ended up settling for $1.5 billion, which was the largest copyright settlement in U.S. history. So the expensive lesson here is that fair use might protect the training, but it won't launder the piracy. That's one court. 2 days after Bartz came out, Judge Chabria, same district, Northern District of California, he reached a similar bottom line. Training is fair use, but he got there differently. So unlike Judge Alsup, he did not carve out the piracy issue. He treated the whole thing, downloading from shadow libraries, building the training set, the intermediate copying piece. All that was a single transformative process. So under Cadre, fair use potentially covers the entire pipeline, including the piracy. But what keeps content owners in the game in this case is Judge Chabria warning that a market dilution theory could have changed the calculus and could change the calculus in future cases if the plaintiffs can show that AI-generated works are flooding the market and competing with the originals. Then even highly transformative training might not be fair use. The problem, according to Chabria, was that the authors didn't put on that evidence. What he said was a potentially winning argument. To be fair for the plaintiff's lawyers, it is an argument that no court has ever accepted. It is an entirely untested theory that the judge spent 30 or 40 pages in dicta talking about, and potentially providing a roadmap for future cases. But it really remains to be seen whether that is viable, and I'll be interested to see what Christine and Peter have to say about that. But the takeaway from Cadre is that it does not bless all training. It blesses training with a record that does not show harm. And the last note I'll say about Cadre is that he pushed back on an analogy that Judge Alsup made, that training AI is like teaching children children learning how to write. And he said, when it comes to market effects, using books to teach children to write is not remotely like using books to create a product that a single individual could employ to create countless competing works with a minuscule fraction of the time and creativity it would otherwise take. So I'm going to move now quickly to the output cases. And Concord Music versus Anthropic, that deals with some interesting secondary liability theories that may come into play when models are capable of reproducing protected content. So here, music publishers allege that Claude outputs nearly word-for-word copies of copyrighted lyrics when prompted. And after a few early wins for Anthropic, the publishers amended their complaint. And in October of last year, the court denied Anthropic's motion to dismiss the amended secondary infringement and DMCA claims. And the key issue was knowledge with respect to contributory infringement. And because Anthropic had built guardrails to prevent Claude from outputting lyrics, that cut both ways. So if you're scanning for infringing outputs and you're blocking them, you arguably know infringement is happening. And so the court found that that was enough to plead actual knowledge at the pleading stage. And since then, Anthropic has cut a deal with the publisher to keep those guardrails in place for existing and future Claude models, with the court stepping in if there are disputes. There's also a DMCA claim for stripping copyright management information, things like author names and notices out. And publishers allege that Anthropic used a text extraction method that removed all that metadata. And the court found that theory, there was enough to plead intent and allowed that to go forward. So that case is going forward. Dow Jones versus Perplexity is about RAG, retrieval augmented generation. Perplexity is self-avowed answer engine. It has an index of content from different sources like the Wall Street Journal and the New York Post. And the publishers allege infringement at 2 points, both the copying of the articles into the database and then outputting these verbatim chunks, they say, of copyrighted content. And here, the market harm theory is pretty straightforward, because if you use Perplexity, you get the information without having to visit the paywalled sites. And the idea is that if your product delivers the substance of an article so that users don't need to click the links, the publishers say that's substitution. There's also a Lanham Act angle, because Perplexity, as many LLMs do, sometimes hallucinates, attributes made-up information to their publications using their trademarks, and the court found that stated a false designation of origin claim. And finally, Lerman versus Lovo, that is a case that illustrates the limits of federal law for AI-generated content. And this was a case involving voice actors who discovered that this tool, Lovo, had cloned their voices. They essentially gave up recordings of their voices under false pretenses. These guys signed up for Fiverr, were told that the recordings would be used only for internal academic research, and then later found them marketed as AI products. And the federal claims here largely failed. On copyright, the problem was that the Copyright Act protects recordings, not voices. So imitating how somebody sounds, even with AI, is not copying a fixed work. This has to do with this, if you look at Section 114 of the Copyright Act, imitation as opposed to actual duplication of a recording. The Lanham Act claims also failed because the voice was not being used as a trademark to identify a source. It was the product itself. But the plaintiffs did get some traction under state law. The New York right of publicity statute, breach of contract, and consumer protection claims all survive. So the takeaway here is that federal IP law, not particularly well suited for voice cloning, but state right of publicity law, at least until there's a potential federal analog, could provide a stopgap. So in 2026, look for the Third Circuit's decision in Ross potentially, which would be the first appellate word on AI training fair use, and then whether other courts or whether other plaintiffs could build the market dilution record that Judge Chabria talked about. So that is AI in a nutshell.
Thanks, Aaron. Christine, Peter, did you guys have any comments you wanted to make on any of those cases? Anything to add?
I just want to mention really briefly, because I do think it's important to see that we're still really sort of stuck in the, the phase where we're looking at the fair use on the training as opposed to the output and whether there's infringement that's occurring. There's really not any cases that really are addressing that situation yet. But on the fair use side of things, what's interesting is this market dilution, because the first factor of fair use, the transformative factor, has always been given, such an important and should be, focus. But then the fourth factor is somewhat got lost in the sauce over the years, I think, and now it's coming more centralized to focus, but in a different way potentially. And the Copyright Office had mentioned this theory, a potential theory about market dilution. So it's an interesting new way of looking at the fourth factor and maybe giving it some more power.
All right. Why don't we turn to? Oh, sorry, Peter.
My only thought was that Aaron's initial point about how everything's changing and he's got enough to talk about already in 2026. I'm really looking forward to where it goes next because it just seems so all in flux.
Absolutely.
Sure.
Everybody's gonna make deals. That's what's going to happen next.
Christine, you want to start us off on the copyright substantial similarity cases, please? That'd be great.
Yeah, yes. And again, thank you to the association and thank you, Pierre and Loeb for giving us these summaries. I'm focusing on, if you're looking at the materials, 4 cases under 6, which is the substantial similarity section. I'm looking at 6.4, 6.6, 6.7, and 6.10. And probably in that order, because that is actually chronological. And looking at the substantial similarity and how the courts have handled that concept, going and looking at this from the big picture, everyone is well aware of how things have developed over the years with respect to the concept of protectability, musical building blocks, protectability, not just in music cases, but generally. And it's been evolving, with some seminal cases. There was a lot, talk after Blurred Lines, then some cases came down, particularly in the Ninth Circuit, that dealt with this issue of protectability up to the Ninth Circuit. Skidmore, Peter's case for Zeppelin, the Dark Horse case, Gray versus Hudson, that we handled. And in the Second Circuit, we had the Ed Sheeran case. So you've got this movement forward on courts looking at, I think, more carefully in that space, what is protectable expression versus, what is unprotectable and can't be monopolized by the plaintiffs. And in the theories that have been developing in these cases, you start looking at a focus on selection and arrangement. So the first case, the Larble case, my case, which ended at the district court level in a summary judgment win for the defendants, involved the Dua Lipa hit Levitating. There were 2 songs that the plaintiffs claimed were infringed by Levitating, one that was authored by the plaintiffs, and the other was sort of bought in a litigation where they own the copyright. And both of those 2 plaintiff cases involved a descending, ultimately admitted, 20-note scale progression, 5 groupings of 16th notes in a descending minor scale, different B minor in Levitating and D minor in the others. And what was important here is getting ultimately and winning summary judgment on that, a recognition, not just by the court, but in the by virtue of the plaintiff's experts not being able to really get away from the fact that with this really, even though it's a lot of notes, it's a scale, and it's a scale that simply progressed down. And so the court said, according to the plaintiffs, their actionable copying distills to one descending scale plus one additional identical note. So bringing in the selection and arrangement concept that had been adopted in Sheeran and I think fleshed out more from the Ninth Circuit's original Satava case, was that that's not enough. Two elements is not going to make a selection and arrangement. It's not sufficiently numerous or original enough to constitute a selection and arrangement that's protectable expression. And so that was the result in that case. And I think the next three cases coming after that, not reviewing that at all, but come out of the Ninth Circuit. And other than the last one, which is not a music case, and I think that's an important distinction, don't go in the way of, as a matter of law, there's no protectable selection and arrangement. So the first one, Sound Color versus Sam Smith, Ninth Circuit 429, the Ninth Circuit reversed the district court grant of summary judgment that there was no substantial similarity as a matter of law under the extrinsic test, which I'm presuming everyone knows what that is. And there were two songs, and the title was the same. So there was a lyric commonality. And then there were, a number of musical elements that the plaintiffs claimed were in common between the two works. And so in this particular case, the court sort of backed into a little bit of distinguishing Dark Horse and distinguishing some other cases and saying, in this particular situation, we're not going to say the selection and arrangement as alleged is going to be unprotectable as a matter of law. Jury could consider that the number of elements that have been placed in common, and clearly unprotectable in themselves. So again, the selection and arrangement theory has developed because the original attack a lot of the times, there's a number of elements and they may be all over the work, but ultimately, if they're not in one particular section, you're looking almost like a constellation. And this is not what courts are doing really anymore. They're looking at, when you have a focus of infringement, if you have unprotectable elements themselves, if they're arranged in a particular way that essentially is the same in substantial part between the defendants and the plaintiff's work. So this is not just random similarities throughout the work. Call it a combination. You can't. You have to show that there's some thought behind this arrangement. So that was the outcome in that case. And it also rejected the thin copyright doctrine. It didn't want to look at that. And that was something that the district court had adopted, I think, one of the first times ever in a music case, in the Dark Horse case. But the Ninth Circuit didn't reach that issue, didn't have to, because it found the selection and arrangement in that case was unprotectable expression. So this is, I guess, looking how courts are now, somewhat struggling with or trying to understand how to best apply the selection and arrangement doctrine in a music case. And the next one, which is also out of the Ninth Circuit in August, Ambrosetti versus Oregon Catholic Press. This was a niche music case in the sense that both of the parties came out of a Christian liturgical background. So the court focused a lot on access issues. I'm not going to talk about that too much, but ultimately the reason why it reversed the district court grant of summary judgment was because it didn't agree with the access and the striking similarity conclusions that the district court had made. So it found that the case could proceed. And again, looking at, in this case, there were 23 similarities that were highlighted throughout the work by the plaintiff's expert. And this was a situation where the court was, again, looking to find whether or not under the selection and arrangement doctrine, there was sufficient grounds to throw it out. And I think there's some meaningful discussion in that. So let me just pull that case out. Yeah. Well, defendants would have us break down the works into pitch sequences, rhythms, and metrical placements and analyze each element alone, doing so would be improper. Now, this is where it ultimately gets confusing, because in the extrinsic test, you're supposed to be isolating the elements to determine whether or not there's substantial similarity in protectable expression. So you've got to first understand that with each one. And then if you're now at the selection and arrangement concept, okay, you could have a selection arrangement of protectable and unprotectable, but oftentimes it boils down to just a selection arrangement of unprotectable. And now you are looking at whether or not those unprotectable elements have any role any longer in a filtering process. And this is where the Sam Smith case said they're two distinct concepts. We're not going to look at filtering any longer when you're dealing with selection and arrangement. And when I talk about the next case in the Ninth Circuit, you can see there's some tension there, but in a non-music case, because this court's in the Ninth Circuit and the Yanné Top Gun case said they're not distinct concepts, filtering and selection and arrangement. Because the whole concept of all of this is to get to figure out whether or not what's being sued over is sufficiently protectable expression. And it's literally a new way of highlighting how a combination, what are the contours of this combination? What does a plaintiff have to do to prove that, in fact, the combination itself is protectable, whether everything inside of it is not? Prior art is relevant still, obviously, on that, looking to see whether or not there are other works that relate. And I think in the Ambrosetti case, one of the challenges there was because there were so many similarities, there was not an ability to find compelling prior art. So in that case, we see that one moving forward and no summary judgment. Now, in the last case that I'm going to talk about on this topic, which is, as I think Aaron said, coming into 2026. It's January 2, 2026, the Yanné versus Paramount Pictures case. And again, up to the Ninth Circuit. And here, summary judgment was granted below, and now it's affirmed. And this involved a case with a plaintiff who had written an article about Top Gun Navy fighters. And this article had a lot of discussion about particular fighters and how they handled matters. And so they brought a suit against Paramount and others, claiming that Top Gun Maverick, the movie, infringed the article. And in this case, again, because it's not a music case and we're dealing with essentially a selection and arrangement analysis, we're looking at a different approach, because you've got facts in the article that the court heavily focused on. We're looking at a situation now where we're looking at not just an expressive work, but an expressive work that contains certain facts. So if the facts in the article are parallel to some extent in the movie, that's not going to help you, plaintiff. And you also have a different analysis with literary works, for the extrinsic test. For literary works, the test focuses on articulable similarities between the plot, themes, dialogue, mood, setting, pace, character, and sequences of events in the two works. So you've got only certain specific areas that can be looked at. And so the court went through its analysis. It went through the plot, it went through the characters, the dialogue, and it literally came to the conclusion that, no, we cannot provide the plaintiff with assistance here because there is no similarity in the overall expression individually or as a matter of a combination. Here, the court also excluded the plaintiff's expert because it didn't filter out the unprotectable elements. And that is an interesting thing, because in some of the music cases, it goes both ways. Sometimes they get excluded, sometimes they don't. But again, in the selection and arrangement issue now, that's the focus of many music cases. Is it going to be something where there's going to be any kind of relationship to the unprotectable elements and the combination in the nature of a thin copyright, perhaps, or in the nature of they're still relevant because you don't want to block and have monopolies on creative expression? So when you're dealing with a combination of unprotectable expressions, arguably you're already below the scale because you don't have protectable expression in the interior part of this combination. So that's why this Yanné case, when it turned around and it said that filtering and selection and arrangement are not distinct concepts, truly distinct tests. They're not. They are looking to determine whether the similar elements are protectable or unprotectable. I would submit that there's some relevance still to the lower level of protectability in the contours of the combination. That has relevance, whether it's filtered out or not. It's still a relevant potential thing to be looking at in the hierarchy of protectability and the strength of the protection of the particular passage. And because music cases have always been second-class citizens in the terms of getting that music building block understood, I think there's potentially even more relevance there.
Great. Thanks, Christine. Aaron, Peter, any comments on that before we move on to Biani?
I think just real quick, the cases that Christine talked about really do highlight the importance of expert testimony, getting the right experts, having them say the right things. This is something that Judge Wardlaw has reversed cases in the Central District that have decided these substantial similarity cases on the pleading stage, saying that experts are needed. What's interesting in the Top Gun case is that Paramount's expert was actually a former Top Gun instructor, somebody who was a commanding officer who basically opined that the article accurately described the Top Gun program. The court found all that helpful in doing the filtering. So it's, contrast that to the other expert who didn't do the filtering. But yeah, ultimately, I think this trying to figure out where we draw the lines with respect to selection and arrangement, filtering, and Peter will talk a little bit about that in the context of the Kat Von D case, I think as well.
And I think that Aaron's comment really leads into the next case that we're going to talk about, which is Biani versus Showtime, because of this what's been going on in the Ninth Circuit, where you have these unpublished decisions that either affirm a 12b6 dismissal at the pleading level of a copyright infringement case, or the Ninth Circuit reverses them. And for example, the Judge Wardlaw unpublished opinions where they reversed because there was no expert available at a 12b6. In Biani versus Showtime, the plaintiff sued over the Showtime show Penny Dreadful, claiming copyright infringement. The plaintiff was a member of a role-playing forum set in Victorian times in London, and claimed that 3 of the characters in the Penny Dreadful television series had been copied from her postings on the forum. The interesting part, and I think very important part about this case, is it was dismissed at the pleading level. Now, there's a long history going back to, I think, a MAP case in the 1940s in the Ninth Circuit, that if the works are in front of the court at the pleading level, it can compare them. That really kind of doesn't really work often, if at all, in music cases, because music is unique, but this wasn't a music case. And the district judge compared the works and concluded, well, first of all, concluded that the plaintiff had failed to prove access. And because the plaintiff couldn't prove access to establish an inference of copying, the plaintiff alleged striking similarity. The district court found, as a matter of law, that the works were not strikingly similar. And the district court went on to say that under the extrinsic test, where you have dissection and objective analysis, that it didn't pass muster either. Importantly, the Ninth Circuit, and on either side that you're on, in terms of guidance, importantly, the Ninth Circuit actually affirmed a 12b6 dismissal of a copyright infringement case without any experts. The Ninth Circuit agreed that the works were not strikingly similar. Strikingly similar requires that they be so similar that copying is the only possible explanation, in effect. And the court looked at the differences in the works and said, well, that doesn't pass muster there. The court then went on the issue of substantial similarity to protected expression. Without any expert analysis, it was comfortable going through, pointing out the differences, and concluding that the characters were not substantially similar. So it is, it may not be the end, because technically the substantial similarity conclusion may be dicta since the plaintiff had already lost on an inability to plead copying. But it is a sign that there are at least some judges who are willing to, in a published decision, say, if the court has the works in front of it, then it can decide whether they're substantially similar or not under the extrinsic test at the pleading level. Otherwise, you have to go through the discovery, summary judgment, and everything else. The next case I was going to talk about is Eden Film Productions versus Lockjaw. And that was a claim against the television show Yellow Jackets. The plaintiff had a movie about a U.S. men's soccer team that crashes on a deserted island after a match. The Yellow Jackets television series involves a girls' soccer team that crashes in the Canadian wilderness on the way to a match. It also has two separate timelines, the past and the present, and the plaintiff limited their claim to the one that was applicable to the claim similarities. Once again, now this is a district court decision, but a motion to dismiss was granted under the extrinsic test. The court did the analysis going back to Shaw versus Lindheim in this circuit of comparing plot, characters, and all that. It found some of the similarities were just too abstract. One example was that in Yellow Jackets, a character escapes to a cave after setting fire to something. And in the plaintiff's movie, a character commits suicide. And the plaintiff argued, well, they're both about escape. Escape from people chasing you and escape from life. And the court said, well, any similarity there is just at the abstract level. And we know from cases like Three Boys Music that the similarities have to be concrete. Some of the similarities the court held weren't even similarities at all. The plaintiff had argued that the movie alludes to cannibalism, while in Yellow Jackets, there's a discussion about whether to keep food from survivors and store the food, which hardly has anything to do with cannibalism. And it was just overreach by the plaintiff and probably didn't do themselves any good on it. And the other similarities were commonplace to the survival genre. Now, that to me is interesting, and I don't know the record in the case, but there was no expert to testify as to what the survival genre was. I think the kinds of things that were described, I think any person, any reasonable person would agree that they're commonplace to a survival thriller. One example was that the plaintiff claimed, well, both shows demonstrate that people are capable of violence when they're trying to survive. And, in the 12b6 standard, plausibility talks about, the case law tells us that plausibility talks about what is in the normal experience of people and the judge and all that kind of stuff. And I think, you don't need an expert to conclude that the fact that there's, violence in a survival thriller is just common to survival thriller genres. But it is, again, interesting because it is a 12b6 dismissal. The next case is actually different from all of this. It's a tattoo case, so it's an image case. It's Sedlick versus von Drachenberg, and the defendant is a tattooist, a very well-known one apparently, and was sued because she did a tattoo on someone that was based on a well-known photograph of Miles Davis. Now, I think it's fair to say, if you look at them, it's clear, and there was no dispute that she created the tattoo based on the photograph. It's a little bit more complex than that insofar as there's no copyright in Miles Davis's face. Anyone can depict that, Now, usually photographs, we're talking about similarity in pose, lighting, film speed, and all that kind of stuff, little of which, if anything, actually ended up in the tattoo. The only thing that really seems to stand out from the face is Miles Davis is depicted putting his finger on his lips as if to say shush or something, and that's in both, but that's hard to distinguish between the idea of putting your finger to your lips and saying shush and the expression of it. So it's actually a fairly complicated kind of analysis. It did go to trial, and the defendant won. Now, Christine referred to the extrinsic test. That's the objective test. The intrinsic test or the subjective test is the one that is reserved, for the jury. And, we've got that statement in 40 plus years, I think, of case law that the intrinsic test is reserved for the jury and the judge can't decide it, or unless he's sitting as a fact finder, I suppose. But the panel had a real problem with this because the jury decided that there was no similarity under the intrinsic test when they're basically identical. And the panel was kind of flummoxed by it. If you watch the oral argument, they say, what do we do? I mean, this is reserved for the jury, and they said something that makes absolutely no sense to us because they're basically the same image. And what they ended up doing was the panel affirmed on the grounds that the jury had found it. And there was a fair use issue as well on some drawings that were used in the tattoo process. But there was two concurrences. And together they argue that we should abandon the intrinsic test in the Ninth Circuit. That is a very interesting, to put it mildly, proposition. It would change law going back, to the 1980s, maybe even earlier. And I'm not going to tell you what I think because I'm still working through it. I think, the intrinsic test, the idea of subjective similarity, has some appeal. I know Aaron has written, and I thought it was a very thoughtful observation on his blog, that what this really comes down to is, who does the jury believe when it comes down to experts? And sorry, Aaron, if I muffed that, but basically, if you get testimony as to what the objective similarities are, does that necessarily mean that the plaintiff wins or loses? If they're objectively similar, but maybe not in total concept and feel, which the concurrences point out aren't copyrightable elements, and so it's just an interesting decision because it opens the door to a discussion about whether the intrinsic test should even exist.
What's really important about it though, Peter, and I think it is interesting because Second Circuit lay listener test, total concept and feel, to the extent the Ninth Circuit thinks they have the problem themselves all by themselves on that, it's not. They're very similar. Right, and in the Second Circuit, you also have the objective test. It's not called the extrinsic test. Was similarities probative of copying ultimately, and that is where the gatekeeping function is supposed to happen. So if you get past the extrinsic test as a plaintiff, and then what you have protectable expression supposedly, right, and then the fact finder is supposed to determine whether it's enough of protectable expression to rise to the level of improper taking. So, to me, it's nothing really. How else would one do it? Because you have to look at them both in tandem, the extrinsic and the intrinsic.
Well, what do you do if you've got two songs that objectively are the same, but one has a very slow tempo, one has a very upbeat tempo, so the feel of it is, the subjective feel of it is different?
So they got past the extrinsic test, the plaintiff?
They get past the extrinsic test.
They get past
and the defendant argues, but the feel is completely different. Can you lose just on tempo? I mean, but I you don't have to answer that. But,
you know what? Here's the question in my right. Ultimately, there's the question of what is the relevance of tempo to all of this? Is that fit in the extrinsic test or the intrinsic test? Because a lot of people try to fit it in the extrinsic test on the plaintiff too.
Yeah. Well,
Okay.
I'm sure you know this, but this whole idea in the Ninth Circuit about not wanting judges to decide the intrinsic or subjective similarity goes back to, I think, an Oliver Wendell Holmes opinion, where he said that judges shouldn't be the ones who decide things like, music, pop culture, similarity, whatever, that their training doesn't give them that expertise. But and it's always interesting to me. I see these Second Circuit decision, and there was a district court decision in a music case within the last couple of months where the judge just said, I listened to them. They don't sound similar to me.
Yeah, I've had one of those. I've had one of those happen on a 12b6 motion where the court listened to the two songs and threw it out because there's no reasonable jury or person could have heard anything, that, and even if they're in the same genre, it doesn't matter. Different song. So they can do it. I mean, it's just rare.
Yeah.
Not so rare literary cases, though.
Right.
There, it happens all the time, I think.
But I think what's even more rare than having a judge say that no reasonable juror could find these to be similar is a jury saying they're not similar, and then a judge taking that away or reversing it, which is
Oh,
where I think these judges felt hamstrung, and we'll see whether Kat Von D goes up en banc and the total concept and feel is revisited by the Ninth Circuit as a whole.
Could be.
Yeah.
Aaron, why don't we move on? Tell us about the Atticus case.
Yeah, so this one is interesting. It involves one of my favorite books, To Kill a Mockingbird, but actually the adaptation, the stage adaptation. So in 1969, Harper Lee granted Dramatic Publishing the exclusive license, right to license stock and amateur productions of her novel. And Dramatic's president, Christopher Sergel, wrote a stage adaptation, and this is the version that has been used, for generations of high schools who put on To Kill a Mockingbird. It's been used for over 50 years. But in 2011, Harper Lee, while she's still alive, exercised her termination right under 304C to recapture the copyright, to terminate the grant to Dramatic effective 2016. And after the termination, her estate cut a new deal with Scott Rudin and Aaron Sorkin to develop a new version, which opened on Broadway in 2018, became a really big hit. So where it gets interesting is that Atticus LLC, the company that held the rights to the Sorkin play, wanted to then license that version for stock and amateur productions like high school plays. And this is, of course, the same market that Dramatic had dominated for decades. And Dramatic said, you can't do that. We have a derivative works exception under 304C. And because our right was exclusive, that exclusivity survived termination under the derivative works exception. So for those who may not be familiar, the derivative works exception says that after termination, the owner of a derivative work can keep exploiting it, quote, under the terms of the grant. So Dramatic's position was that the terms of the grant included exclusivity, including the 1969 promise that Lee made to Dramatic that the Circle play would be the only one that was licensed for those amateur productions. So they argued that they can block competing stage versions forever. So creative argument, but ultimately not a good one, and shot down correctly, in my opinion, by the Second Circuit. Court held that the derivative works exception does, of course, let Dramatic keep licensing the Servo play, but it does not let Dramatic fence out new adaptations. The right to authorize new derivative works is part of the copyright in the underlying novel, and that reverted to Lee. So in essence, Dramatic was conflating the rights that it had in the play with Lee's rights in To Kill a Mockingbird itself. And the upshot of the theory was that if these guys were right, termination rights would be meaningless because an author could never authorize a new adaptation if the original grantee's license had been exclusive.
Exactly.
So today, both can be licensed for stock and amateur. The Sergo play lives on under the derivative works exception, but it no longer has the market to itself. Interesting case, I think.
Yeah, I agree with you, Aaron. I think the Second Circuit got it right. And as I was reading it, the word absurd came out of my mouth before I read it in the court's own decision, that it would just be an absurdity. I mean, it would have, I think, allowing the exclusive rights to remain with Dramatic, it essentially would have just gutted the whole termination and the whole purpose of the termination. So I think they got it right. It was a good decision. Peter, why don't you tell us about the Enos versus Walt Disney case?
Absolutely. There, the plaintiff had there are actually multiple plaintiffs, and one of them had prepared a whole bunch of musical compositions. They developed this sort of show that they would put on, and in the show and in books and other things, they included a blue-eyed turtle with a ukulele. And they had a relationship with Disney, and so access wasn't really an issue. And then Disney in Hawaii at one of its resorts started using a blue-eyed turtle with a ukulele. So, understandably, the district court denied Disney's motion to dismiss, since, the characters were pretty much, they were both blue-eyed turtles with a ukulele. The interesting thing I thought was that Discovery turned up that Disney had actually come up with artwork on its own for a turtle with a ukulele, not with blue eyes, but a turtle with a ukulele. And it wasn't until after that that the plaintiff, who had a turtle with blue eyes, added a ukulele. So if you take the ukulele out of this equation, the only similarity is that Disney might have copied, in theory, was a turtle with blue eyes. And the district court just said, no, you can't copyright a turtle with blue eyes. That just doesn't work. The turtles themselves were, both turtles, cartoonish, but, not really, clones of each other in any way. And so the judge granted the motion for summary judgment.
All right.
Business. We should be creating turtles and other characters.
Well, I didn't see it.
Go with the ukulele? Who thinks of these things?
Just give it a musical instrument.
Well, it's supposed to indicate music, awareness of the turtle or something, but I didn't really see it in the opinion. But all of us who've been to Hawaii, and I'm sure all of us have, that's where ukuleles, I think, come from, basically. And there's turtles. And so, the idea of a turtle with a ukulele, who, by the way, in one of them also surfs. But, it just seemed, Christine used the phrase earlier about granting a monopoly. I mean, does anyone really, are they entitled to a monopoly on blue-eyed turtles? Yes.
Right. No, I don't think so.
Christine, why don't you tell us about the Woodland Hill case? It's a copyright access case.
Okay. Yes, and nude photographs, which I love. So this is actually it's Peter's case, and great job getting it summary judgment. Oh, motion to dismiss actually was affirmed at the Ninth Circuit level. So what you have here in this case is some photographs of a plaintiff who poses semi-nude. Lil Nas, the defendant, Instagram photos posted semi-nude, and they're supposedly substantially similar to each other. Plaintiff sues Lil Nas, and again, the support notes as one apparently does these days, quote unquote, posted on Instagram. So the focus in this case, and why we're talking about this outside the substantial similarity, although the court does go through all of that as well, and compares the photos. I'm not going to do that. I'm going to talk the access discussion, because if we've all noticed, the access cases, or most of the access cases that we have been dealing with for decades, are related to the brick and mortar world. So the two theories of access, the doctrine being providing the defendant with a reasonable possibility or opportunity to view or hear the subject plaintiff work, usually comes down to two arguments. One, that somehow the defendant had an opportunity through a chain of events. Usually it's someone gave it to someone who gave it to someone, or some other chain of events, because the plaintiff doesn't have the second option, which is widespread dissemination. So now that we're in the internet era, and we have been for quite a while, trying to find some guidance from the courts on what is sufficient in terms of widespread dissemination of a plaintiff work that is either posted or streamed or downloaded on the internet is an exercise that is frustrating, because the cases are not developing in that area. They will eventually, because they have to. And in this particular case, you read the case, because on the one hand, the plaintiff admitted he only had like 8 to 75 likes. So he said, I don't have widespread dissemination. But then he said, okay, I have a chain of events. But then the court went through a whole analysis of effectively widespread dissemination nonetheless. And it is about how on the internet, there's actually more ability and it's easier to have access potentially because of algorithms and the like. So then there's also the flip side of that. The court then somehow goes to, well, but it's all speculative because you still have some searching, issues, and you still have the issues with respect to, proving that if there's an algorithm that somehow or another that particular defendant was given the content. So I think that the issue with respect to widespread dissemination on the internet is going to become a larger question mark here. The court shut it down on both theories. Chain of events, no. Widespread dissemination, no. And then again, also address substantial similarity, but threw the case out on access as well. And I think in reading the discussion, which I encourage everyone to do, you can see that the court was really struggling and kind of going back and forth itself on whether or not there is, posting on the internet enough alone. There's plenty of cases that say that's not enough, but it's the dissemination and the likes and the streaming and the numbers and all of this stuff and we had this in the Dark Horse case, and it wasn't the result of the decision, but we ultimately demonstrated that you could have millions and millions of streams or downloads, and that's like a bucket with sand at the bottom. That's what that means. It's not a lot in this universe. So we have to look now, what does it mean? Brick and mortar, 17,000 copies of a book or an album in a store, not enough. How does that translate to the digital platform world? We don't know. So read the decision. It's very interesting because this is something that courts are going to have to wrestle with, and it'll be fact-based, I'm sure.
Okay. Peter, you want to talk about the Shelby versus Halicki case? This is a copyrightability case. I got to mention that I still can't believe this dispute is still going on for so long. I back in 2005, I wrote the motion for summary judgment when I was still at my first law firm, on behalf of actually the company that Shelby had hired to make these cars, unique motor cars, and it was the winning summary judgment at the time. I think I left the firm before I think the appeal, so I can't remember how that all went. I just had to throw that out. I saw this name and I'm like, this continues. This case just keeps going and going. It's like the Energizer Bunny.
That's crazy. That's 2 decades later. They're still fighting. Very quickly, because I know we're getting close to the end of the time, but the defendant, Halicki, had the rights to a 1974 original version of Gone in 60 Seconds, which was remade with Nick Cage in 2000. And it's basically about these people who are challenged to steal a certain number of cars, 48, 50, and in one night. And one of the cars in both the movie and in 2 other movies that the defendant had before the remake, and in the remake, one of the cars, a Ford Mustang, was referred to as Eleanor. All the cars had female names as code names. And Carroll, Shelby, and Halicki had a couple of, well, first of all, apparently the defendant, Halicki, had authorized the remake since she owned the movie and there wasn't a case over it. And she had retained or obtained merchandising rights on the remake, which meant in theory she could sell merchandise that was based on the movie. And so she felt that Carroll Shelby licensing by licensing Ford Mustangs that looked like Eleanor had breached. There was a settlement agreement, then there was another breach, and then again the litigation. This litigation hopefully isn't the same one that Pierre was on, but the principal question was whether Eleanor is a copyrightable character. And the copyrightability of characters has sort of a mixed kind of background. Learned Hand said it had to be the story itself. I think he referred to Falstaff. The Ninth Circuit, in a ruling that was largely thought to be protective of, I forget the Sam Spade author, said you can't protect a character. So he's having granted exclusive rights to one story. He couldn't be barred from doing another Sam Spade book or something like that. It came then there was the James Bond case where James Bond was held to be a protectable character. Then there was the Batmobile case where the Batmobile was held to be a copyrightable character. And what the court did in the Eleanor case was it applied the test from the Batmobile case. And one of the requirements is that the character to be protectable must have both physical and conceptual qualities. For example, the Batmobile does certain things that, well, actually, Batmobile is a bad example, but James Bond, that character has conceptual qualities, such as, and so a physical character like the car would have to have some agency or personality or something conceptual beyond just its physical existence. It would also have to, and it doesn't. The Eleanor car is driven and crashed and driven and crashed, and that's about it. It doesn't make any decisions. It doesn't have any personality. It has no conceptual qualities beyond being a Ford Mustang.
And they were two different cars, Peter. The original movie had a different Ford Mustang. It was an older model, and then the Nick Cage one it was a Shelby. So there was a differentiation there as well, that it didn't necessarily denote to the same type of vehicle even.
Not even the same type of vehicle, but also different coloring,
Right.
and including in the 2000 movie apparently. And so, yes, you're absolutely right. And another requirement in the Batmobile case test that was the character has to be sufficiently delineated with traits and attributes that you would recognize it anywhere as being the same. So whether it's Daniel Craig or someone else playing James Bond, it's James Bond. When he asks for martini and he's got a tuxedo, and the same thing with the Batmobile. Whether
Chicken not skirt.
I didn't say that. And then finally, it has to be especially distinctive, not a stereotypical character. And look, it's a Ford Mustang. I mean, come on, it's a beautiful car. It looks like a lot of fun, but it's just a car. So it didn't pass any of the three requirements, and so the court ruled that the Eleanor is not a copyrightable character.
Well, we're at our time. We had one case left. I don't know if Aaron, if you want to jump through it real fast, the Santos versus Kimmel, or we could switch to questions.
Yeah,
Or
maybe
Ooh.
switch to questions. I don't know, whatever.
Let me see what we got.
Chat. I see.
I think this is a AI question from Jay Doherty. How can courts possibly rule there's no potential to harm potential markets when there are so clearly evolving markets for licensing for training AI?
Yeah, I mean that certainly has been developed much more in 2025 than had in 2024. In the Westlaw case, Judge Bibas did give that some credence, saying that Ross intended to create a market substitute for Westlaw and did not disprove the existence of a potential market for training data, which has been licensed and is licensed in other contexts as well. I think where there's some tension is that some courts think of this as more of a circularity issue, because if copyright holders could defeat fair use just by saying we would have licensed this, then fair use would swallow itself. So every fair use would be infringing because every use is theoretically licensable. I do think that there will be a lot more evidence coming in of the licensing market, but we do need to distinguish that from just a market dilution theory, where it's not a issue of substitution so much with respect to this particular work, but rather, the genre overall.
Thanks, Aaron. We have another question. This is from Greg Raymer. Generally speaking, with respect to similarities, strikingly or otherwise, to what degree would you say that Scenes of Fair is coming into play, especially given the vast and increasing library of scenarios?
Want to take it, Peter, or I could take it? I don't care.
I defer to you.
Well, Sons of Fair has always been a doctrine that essentially is about unprotectable expression. And you know, not used so much in the music context, more in the literary, film, et cetera, you know, English speaking comparative models, to see whether something's a sense or fair or not. In the context of a music, you know, case, we talk more or less about just unprotectable expression, and we talk more about, you know, building blocks is becoming very current because people understand chords, they understand, you know, certain things that are, you know, in lessons books that they can't monopolize. So I think it's always been there. It's just the application of it. And again, all of this really comes down to, at the core of this, what can someone monopolize?
I would add that to me, Sons of Fair is sort of a subset of commonplace. It has the additional element that it flows from the idea that's being depicted. And so if you have a Western, there's going to be cowboys and all that kind of stuff. And musically, I think Swirsky talked about, the district judge who was reversed, talked about how certain parts of the music, the same similarities, were actually Songs of Fair. And the kind of thing you see is like, well, if you have a musical phrase, you want to end on the tonic because otherwise it just sounds crazy or something. You know, there's certain things that happen in music. Music is very, very complex. And there are certain things that happen, and I can see Christine's laughing. And
It's not so much anymore, though. That's the problem. There's so many people using very similar things, and you know, the pop music world or hip hop music world, things are not, you know, the level of originality. I think in some respects, there's a lot of use of commonplaces.
yeah, my point was different.
Commonplace is the key.
My point was different that you know, you have a limited number of notes, only some of them actually work. There are things that go on in music, you know, with chords or whatever, and that just naturally flow from how the human brain works and music works. There are things that are discordant. You wouldn't do something that's discordant. And so the complexities basically limit your choices. And so things become commonplace even when we might not think that, you know, that they're commonplace. It may not be the same 5 notes, but it may be some, in effect, structural thing that makes them commonplace.
Yes, and Dark Horse, actually, that was an issue because
Yep.
there was a concession that there was a natural tension to resolve down to the tonic, and that's a lot.
Yeah, exactly. Exactly.
So we have a question from Richard Jefferson. This is something actually, if we would have had time, I would have liked to touch on it, but since there's a question, might as well bring it up. Does anyone have thoughts on whether the Fifth Circuit decision in Vedder versus Resnick affirming a global copyright termination right will survive? And we touched on this case when the lower court made the decision last year, and I don't think we had thought that this would get affirmed, but
This is a long conversation.
it is a long conversation. I mean, it is a
Aaron's
2026 preview.
Do a whole
long
panel.
Yeah,
on this.
this one could.
Oh, we
Yeah,
could go
I mean,
for
if anybody
half
has
an
any
hour.
quick comments they want to make,
I hope not.
Yeah.
I mean, it's nuts, in my opinion.
Well,
That's
you know, but
my
the other
professional
circuits have to
opinion.
rule. I mean, you know, people are going to start, you know, writing letters saying, "Oh, never mind, you can't exploit there anymore." You know, this is going to be. It's going to take a while to sort out. I think.
I mean, I think a lot of the termination cases, we don't see them go to court as much, or I mean, I think a lot of them settle because of nobody wants to split up the rights. So this could be like an atomic explosion where, you know, now, you know, there's going to be a lot more of these claims coming down the pipe. So we'll see what happens.
To me, the irony is that no one thought this was the law. There isn't a circuit decision that says, you know, that what everyone thought was the obvious, that termination doesn't affect rights under foreign law. That's what the statute says. And so, and I'm not taking a position one way or the other, but you know, you're not going to get to the Supreme Court unless one of two things happens. One is you have a circuit conflict, which you don't have because no one thought this was the law.
Right.
Or two, you get, you know, an incredible amount of amicus, you know, amici, you know, coming in and talking about the horrors that Pierre's kind of referring to, of people coming in and saying, look, I sold a catalog, you know, based on the assumption I did or didn't have these rights. And, you know,
There's going to be business disruption. No matter
Yeah,
what.
yeah. I mean, the plaintiff in his complaint, you know, I think himself characterized it as an admittedly novel argument. And I think the reason that there's no circuit split is that nobody really had thought to make it before. But I
Right.
just, if I could just spend a minute, because I've gotten a lot, obviously I have views on this. You can read them on my blog, but I have heard people say, well, isn't this good for creators? You're anti-creator if you are not for this case. And this is really about territoriality. So if you have a situation where copyright truly arises in the country, only in the country of origin, then that would also have the converse effect where foreign works never
point.
acquire independent copyrights under US law at all. And so under that situation, US termination provisions would not apply, for example, to a French composer who assigns worldwide rights to a US publisher. In that situation, US law was never the source of the right under the logical implication of the Fifth Circuit's decision, which, of course, makes no sense at all. This is a territoriality issue. This is not a pro-artist or an anti-artist situation. It is the inherent in Berne and explicit in Berne that that convention expressly forbids treating foreign authors worse than domestic ones. It does provide for national treatment, and this is just a violation of it without really, frankly, much engagement at all by the judges in these really, complicated international law issues, as opposed to simply saying, well, it's a plausible legal theory that then snowballed into a summary judgment rule and that has now snowballed into an affirmance. It's a crazy case.
It
I,
is.
I would add,
It
I
is.
would add one thing in terms of historical context. In the 1960s, when they were talking about a revision to the Copyright Act, the 1909 Act, there was this fight about authors wanted to retain renewal rights structure where all rights ended, and copyright users, licensees, wanted some kind of relief from that. And this was the compromise. This was the compromise where, you can get back your US rights, but the someone who invested millions of dollars to make a movie retains the right, to continue to use, and they retain foreign rights. That was a negotiated compromise. It may not mean anything at this point, but historically, there was a reason why it was done.
Yeah, and Aaron, to your question about is it not pro artist to be pro this decision? Well, I mean, if we thought the labels and studios fought hard before, I mean, I don't know that if they think they're going to lose it all, then it could be even harder for artists to get their rights back. Just they're going to throw the kitchen sink and everything else. So
Yeah, I'm not taking a position on this call either, like as Peter said.
yeah, no. It's just
Yeah.
interesting,
But,
and who
but I
knows?
think there's going to be a lot more to unravel and digest here than what meets the eye.
Yeah.
I'll say that.
Okay, everybody. Well, we're definitely well over, and thank you guys again. It's been great.
Thanks.
Thank you.
Nice to
That was
chat with
fun.
all of you and do the panel with you guys.
Yeah.
Yes, absolutely.